There we go. Bring this down. And office hours. Office hours. How do you start this thing? I think I'm already connected. Oh, hello. Let me turn on my thing. I think I've already been on. I think I've been on for a while. Anybody there?
I'm here.
Oh, shit. How long have you guys been on? Or how long have you been on?
Can you hear me?
Yeah, I can hear you. Can you hear me?
Yeah, I can hear you. It just shows that I'm muted, so that's what's like,
Yeah, this thing, I don't know. It's bizarre. How long have you been on?
For like a minute or two.
Oh, shit. So you heard me looking for the rules of court and all that stuff?
A little bit.
Yeah, it's kind of weird. We have this sexual abuse case against a school out in Imperial County, and the judge set the trial date and discovery cutoff dates and everything super tight. So our discovery cutoff is in October. It's freaking crazy. And we just...
Did that get issued?
What? Say it again?
Did that order just get issued?
Yeah, like Thursday last week.
Oh, that is really short. What court is this in? Is it state or federal court?
State court. They're not normally that nuts. This thing was freaking nuts.
Right. I know. So far, I only really have Susan's case to compare off of on like the dates and scheduling and how that works at this point so far. That's really short though.
Yeah, it's pretty. Yeah, it's really short. I'm looking at it. What are we? July, August, September, October. Yeah, it's a 90-day window. That's impossible.
Ugh.
It's literally impossible.
Extension?
I'm thinking what I might do is talk to the defense attorneys and see if everybody will stick, because I could have alleged a 1983 claim. You know, it's kind of tenuous, but it's still a possibility. I could have alleged it. And I'm thinking that I may get everybody's cooperation in doing that, in which case they get to remove it. And they can remove it from whatever this guy is out there that's fooling us around. And then we'll get it moved into federal court where we'll get a little bit more equitable treatment. So that's my gut feeling on it. That might be the best way to go. We'll see.
Those bargaining chips are always fun.
What?
So those bargaining chips are always fun.
Yeah, I mean, I'd rather not have to go, try to bargain with the other side like that, because you're always gonna be asked to give up something in exchange for whatever it is you're asking for, even if it benefits them. They're still gonna want you to give something up. So I don't like to do that if I can avoid it. It's just generally not good. How do I move these things? There we go. My arms are too high. I want to lower them a bit. That was probably too much. Yeah, that was way too much. So anyway, what do you got going on? You got any questions, legal issues, anything interesting that we can cover?
Nothing major. I'm kind of at a standstill with all the
what's going on?
My case.
Yeah, what's going on with your case?
Still pending.
That's
pending review.
That's kind of been a long time.
Yeah, I filed June 9th. So we're about like a little under 2 months.
Well, no, if you filed June 9th, yeah, you're a little over 1 month. That's probably a better way of looking at it.
There you go.
So it's not unheard of.
Right. Yeah, I mean, I think when I got the first IFP review, it was like 3 months before I got a response. The second one was like 3 months before I got a response. I was looking at the dockets earlier, and my prior amended complaint, I filed that in November of last year, so it's just kind of no orders since then relating to the review. But I mean, I did ask for the amendment.
Well, they generally kind of take it at their own pace. I can tell you right now, I have a motion to dismiss that the county filed on me down here in San Diego. I can tell you exactly when they filed it. It was a long frickin' time ago. Hold on. It's crazy though. It's been sitting. I actually have cases that are getting ready for trial that I filed after I filed this case, and this frickin' thing is still sitting there. So hold on 1 second. I'll tell you when it is. It takes a second to load. Yeah, but it's crazy. And this judge too, he's a good judge. I really like the guy. And I've had a bunch of cases in front of him over the years. He started off in the municipal court, back in the, I want to say, late 90s, and then got elevated to Superior Court. Spent a bunch of time in Superior Court, and I had a bunch of cases in front of him in state court back when I was doing commercial stuff. Smart guy. And then he got elevated to the Federal District Court. And yeah, the final reply from the county, so this was fully briefed on February 22nd, 2023. So what are we now? We're
July.
Yeah, so
5 months out.
May, June, July. Yeah, literally 5 months out, and I've got nothing. So,
Right. I mean, I kind of don't mind the delay. I start law school in January, so it just gives me more time to sharpen up over the process.
Yeah, that's true. That's true. So it looks
So
like
that's
we.
kind of how I'm looking at that.
Sorry, go ahead. Say it again.
Oh no, I was just saying that's kind of how I'm looking at that. I mean, on one note, I'm like, kind of just thinking, come on, put me off the bench. On the other side, I'm just like, more time to study and practice.
Yeah, well, that's true. But what'll end up happening is once it gets passed, all the work will hit at a very inconvenient moment. That's how it always is.
Right.
Work never lands on my desk when it's convenient or when I have free time. So we've got somebody, it looks like our questioner joined us. So you got any questions for this week? Anything that relates to the stuff I do so I can actually answer you?
Can you hear me?
Yeah, I can hear you.
Can you petition for a writ from the Supreme Court?
What do you mean?
Well, I mean, my understanding is they only hear a tiny little percentage.
Yeah, you've got less
appeals.
than a 3% shot of getting your petition for certiorari accepted.
So, but can you petition for a writ?
Well, no, that's what your petition for certiorari is. It's
Oh,
you got to remember
so there's
you only have a right to appellate review at the lower appellate level, at the bottom rung. Everything you do after the bottom rung, and this is both in state and federal court, everything you do after the bottom rung is discretionary with the court. So in essence, what you are doing is you're petitioning the higher court to exercise its discretion to review what the lower court did.
okay, because the California Rules of Court 1.100, which relates to disability accommodations that the court has to make. It says in it that this is in addition to state and federal rights and procedures. There's nothing subtractive about it. It's only in addition. And
yeah, it's cumulative. Sure, that makes sense.
okay, so it says if you make a request and it's denied by non-judicial personnel, you can have it reviewed by a judicial officer.
Okay, that makes sense also. Did you do that?
I asked for it and they're just ignoring me.
Did you file it in proper form?
You don't have to file it, you only have to submit it.
Well, I'd take another close look at the rules of court, because there's always got to be a filing. Otherwise, you're not. I mean, the court isn't asked to do anything unless you follow the proper procedures. So my first question is, did you follow the proper procedures? There's going to be a filing. You don't just you just don't submit an informal letter that says, "Hey, judge, I got fucked around with on my disability. Please review it." No, you file a formal petition. Probably is required to be sworn in some way and set out factual allegations in some way and request specific relief. So, yeah, it's going to be a formalized process that you have to follow to get anything done there. You can't just write them some informal request.
Well, okay, except that this is disability accommodation, and not all people with disabilities can even make a request at all. So it actually is incumbent on the court to accommodate if the fact that they know somebody has a
you know who
disability
you
is
should
what
talk
triggers.
to? I don't know jack shit. Seriously, I don't know jack shit about disability stuff. There's a guy in San Diego. His name is Richard Prager. All he does is disability work. He'd be the guy to ask about that stuff. But even talking to him, I can almost guarantee you that if you're looking for the court to order some court staff or court department to do something, an informal request is not going to cut it.
Okay, review procedure. If the determination to grant or deny a request for accommodation is made by non-judicial court personnel, an applicant or any participant in the proceeding may submit a written request for review. It says submit, doesn't say file. That determination
No,
to the presiding.
that means file, submit. How are you going to submit if you don't file it?
Well, there's a whole procedure that everything has to be confidential. So,
And did you follow? If there's a procedure, just follow the procedure.
well, but it's not. It says the process for requesting accommodations is they can be presented ex parte on a form approved by the Judicial Council in another format or orally.
Stop! Just stop that right there. Did you go to the Judicial Council Forms website, pull down the official form, fill it out, and then file it?
Yeah, I did, but it's disjunctive. It's on that form in another written format or orally.
Yeah, I can tell you right now, if you don't do it in that form, you're probably not going to get any traction at all.
Well, I did it on the form.
Okay, and do you have a filed stamped copy?
Well, I didn't file it. I submitted it.
Do you have a conformed copy where somebody stamped something on it that says received?
I have a response.
Okay, and what was the response?
The response was, "Forget it. Go
Is
jump
that
in
in
the lake."
writing? Was that response in
Yeah,
writing?
yeah.
All right,
It was.
then file a petition for writ of mandate. Or if the rules of court give you some other procedure to follow when things don't go your way on your request, follow that procedure.
Okay, but if they're just blowing me off, like I didn't get a response.
Well, that's probably because. Well, what did you file? What do you mean you didn't get a response? You just told me you got a response.
I got a response, but the response was, "We're not making any accommodations."
Okay, well that's a response.
Okay, but that was from non-judicial court personnel.
Okay, so what did you do next? The procedure tells you what to do. What did you do next?
I asked for review by a judicial officer.
By filing a form, by filing a pleading, by doing what?
By submitting a form.
Okay.
By submitting a request.
In writing?
In writing.
And did you get a received stamped copy back?
Not yet.
When did you submit this thing?
At least a week ago.
Okay, well, you need to go resubmit it and tell them you want a conformed copy.
Okay.
If you don't have a conformed copy, how are you going to prove you did the right thing? How are you going to prove they even got it?
By my email?
No. You submitted. Are you kidding me? You submitted this thing by email?
That's how I do all my requests.
Oh. Yeah, I don't know what to tell you on that. You're beyond my area of practice, expertise, or even experience. Nothing.
Well, see,
nothing. Stop. Nothing that we do in my world is by email, informal communications, or anything like that. Even private confidential stuff gets filed, and it gets filed under seal if it's private and confidential. The world that you're working in, I seriously don't have any clue how to deal with it if you're not filing stuff. You definitely, at least in my world, you aren't doing stuff with a court by email. So I don't know what to tell you on that.
Okay.
That's
You're supposed to. They're supposed to have an ADA coordinator.
okay.
They don't.
Where? What county is this?
It's the state Supreme Court.
You know what you could do? is in federal court file a federal injunctive relief claim under the ADA.
Oh.
Yeah,
To make
because, I
the
mean,
state court respond.
yeah, they have to have, right? Because under the ADA, that applies to everybody. Government agencies, that applies across the board to everybody. So if they're mandated to have somebody as a liaison to deal with these disability issues as they come up, and they don't, it seems like that's something you may be able to compel.
I could probably compel them to designate an ADA coordinator because it's really clear they're supposed to do that. The problem is none of them seem to understand what anybody's rights are.
Well, that's why you would
Like,
file a lawsuit. That's why you'd file a lawsuit. Again, on something like this, I would talk to Richard Prager about it. I'd ask him, because he does this sort of stuff, and he may very well be interested if, the Supreme Court, the state Supreme Court, is not adhering to ADA mandates. He's got a real hard on for that stuff.
Okay. If you search ADA on their website, you get names of people with the last name Estrada. It ends in ADA. That's it. You don't get ADA.
Oh, I got you. Yeah, I don't know what to tell you on that. I would get a hold of Richard Prager. He specializes in this ADA stuff. Okay. And he may actually have an idea what to do with it. But it sounds like you may be able to, file some sort of injunctive relief action or something like that to enforce your rights under the ADA. Or to enforce compliance under the ADA. I guess that'd be a better way to put it.
Okay.
Yeah,
all right.
But as far as
I have another question, but I don't.
As far as making formalized requests and stuff, though, I can tell you right now, if you're doing it by email, you're going to get fucked. You need to actually be filing stuff, getting conformed copies back. Otherwise, as far as you know, this is just dropping into a ether file somewhere in the back corner.
Okay. That's not how it looks in the case law, but
I haven't done any research on it at all. Maybe the case law you're looking at says something totally different. I don't know. I'm just telling you that again, in the world I live in, nothing is happening if you're sending emails to court staff.
I understand. This is the exception.
Okay, I'm not going to challenge you on that. I'll take your word for it, but I don't know.
I have another question, but I don't want to take away from other people. If
it's not related to CPS or doing civil rights litigation under 42 USC Section 1983, I'm probably going to have similar answers for you as I do on the ADA stuff. I don't know that it's going to be very helpful for you. But let's do this. Let's see. Mike's here. He hasn't been here for a while. Let's see what he's got.
Hey guys, how's everybody doing? How you doing, boss?
Pretty good, man. How are you?
I have a quick question.
Yeah, go ahead.
I guess I learned by my continuous research that when you are serving the summons and complaint for the very first time, that has to be attempted in person by a person and can't be done via all other methods, apparently, correct?
Right. You got to make in-person attempts. And
reasonable attempts, correct?
Right, reasonable attempts. Well, are you federal district court or state court? I don't remember. I did
this is going federal. This is state. This is the defamation.
Oh, okay, yeah, gotcha. I did look, by the way, at what you sent me. I don't remember if I responded by email or not.
No, you didn't, but I want to send it the more complete one. I didn't realize the last few parts, the claims and the purple relief wasn't even on there. So you just basically had the first formalities, the jurisdiction, parties, statement of facts, and then the summary. But I didn't get you the complete one. But if you had any feedback as of what you received.
Yeah,
that's fine too. I'll take anything you got.
Yeah, as to what I received, the stuff that was more or less template form. I mean, it was pretty easy to tell what that was, and that all looked fine.
You heard it.
the stuff where you get
into the background.
Yeah, into the background. It's written in kind of flowery, pretty flowery, non-direct language, almost like I'm reading like a Steinbeck novel or William Faulkner
Right.
or something like that. I would caution against that in the complaint. Mainly because it's a little bit difficult to tease out the ultimate facts. What are the facts that actually happened on X date? You walked out the door, you're holding your child's hand, you got in the car, and then something happened.
I noticed that too. I'm glad you mentioned that, because what I was actually going to do was, I remember in the beginning you were like, some people, they like to, list, one or two claims, and then you have other lawyers that will just list everything and see what sticks. Mine was when, as I was finalizing the claims of my situation, it dawned on me, I was like, I should just do every claim, like the scenario that happened through the timeline that can directly be correlated to that particular event in fact, to the claim and why am I requesting it, again, which will keep me on track during the timeline, but will also allow me to, justify why it is I feel that I'm, been wronged in this particular legal statute. So that's what I'm actually going to do. So I'm glad that that's something that you pointed out, because I got a little carried away with the AI, I think, and it took me away when I was supposed to take it away. But
Right.
but yeah, I'm gonna sharpen that up to be more of a formal legal tone, and not so Harry Pottery.
Yeah, not so flowery. It's okay. Sometimes on a particularly complex case or a particularly egregious outcome, like where a child, has been neglected to death by the agency or by a foster family, or where the child's been subjected to years of sexual abuse in a foster placement, something like that. Sometimes I will write a prologue, but it shouldn't be more than a page, maybe a page and a half.
Gotcha.
Just kind of laying out, the core of that story. What happened. The kid was taken, and the county was supposed to do X, Y, Z, but instead put him in this horrible place, and all these horrible things happened. And then go into jurisdiction, venue, the parties, and then the specific facts. But the specific facts, I generally will write them more or less like a factual chronology, not like a, not like War and Peace.
Gotcha.
Or a Harry Potter or a story.
Gotcha. Just more of a not so much a dry, fact timeline, but kind of the core wrongdoings, and then where, like, I guess it took place, or how it came about, and that was kind of softening it up a little bit for the reader.
Right, the core events, but remember, for the core events, like let's take a warrantless seizure, for example. The core event would be on X date, the defendant social worker sees the child without a warrant, without an exigent circumstance, period. Okay, that is the ultimate fact. That is the core.
Right.
But it's totally conclusory. We don't know anything about how we got there, right?
Right, the context behind it.
Right. So you have to give some contextual background that's just, plain facts. No conclusions, no analysis. It's just the fact of the matter is you woke up Sunday morning, 5 a.m., fed the kids, heard a knock on the door, social worker came in, looked around the house was clean and tidy, there was food in the fridge, the kids were happy and in good health and good spirits, the social worker slapped you in the face, grabbed the kids, and left. Right?
Yeah, I think I kind of did the basically setting the tone in the first section. I think I labeled it the story behind the story, or something like that, and then kind of wanted to give them an idea of what kind of father parent I was before CFS got involved, and then I started to get into the core of the wrongdoings. But then I think I let the Harry Potter kind of blend into a little. I should have flipped it there and got back to my format. But I'm going to do that because I went on Google Scholar just last week, and I was just looking at cases, man, and I was getting kind of discouraged a little bit because all the ones I saw in Contra Costa County was getting. I mean, one got tossed without any option to amend. Another one got tossed out with, but they did allow for amendment. They just, I believe they said that they didn't have any, claim. They didn't say know what they were trying to, basically bring to the court's attention, which is understandable. I can see why. That's why I really got on my claim portion to really, spell it out, why we're here. And then, but by doing that, I need to probably speak, in generally to the event that I feel is correlated with that particular claim. And I got down to like 45, and even though some of them were like violation of due process, there were different events that the AI was telling me what could be a infringement on the due process. So I'm thinking you can't lump them together because they want to each spell out probably individually, or can I like summarize the my allegations of all the ones that I feel like were infringements on like the 14th Amendment to due process, like where they were perjuring themselves, manipulating the court documents, not following through with court requests, things like that.
Yeah.
I just stick with, hey, list them all and see what's, see what sticks, see what doesn't.
There's two different ways you can, well, I guess there's really three different ways you can do it. What you'll see out there a lot of times, some attorneys, what they'll do is they'll just do like jurisdictional statement, venue, then parties. Then they'll do first claim for relief or first cause of action if you're in state court. Battery. And then they'll tell the battery part of the story, hit the elements of battery. Then they'll go second cause of action or claim for relief, judicial deception. They'll just tell that part of the story, hit the elements for judicial deception, sort of like that. So there really is no cohesive story that covers everything. And there's nothing wrong with doing it that way. That's totally acceptable. And in fact, in state court, sometimes that's the preferable way to go, depending on how many claims you have or causes of action you have. If you have a shit ton of them, it's probably better just to tell the story in one block of general allegations. The way that we do it, generally, not in every case, because not every case is amenable to the same process, but in most cases, the way we do it is we will write a chronological story of the case that incorporates the facts to support each claim for relief or cause of action that you're going to see down in the, I guess, tail end of the complaint. And
right.
that way we don't have to keep retelling pieces of the story disjunctively in each cause of action. What you do then is, or claim for relief, what you do then is you just, in the claim for relief itself, your first allegation is going to be, I hereby incorporate by reference each and every one of the factual allegations made in paragraphs, 50 through 182. And then you pick out the specific pieces of the story that are going to satisfy the elements of that particular claim. Does that make sense?
Most definitely.
Okay, and then what some people do now is they'll sort of meld both approaches, where they'll set out their entire story and then they'll retell it or retell pieces of it in each of the subsequent claims. I don't really like to do that because then it starts looking pretty repetitive.
Yeah, that's why I was, because that's kind of what I was doing, because I felt that I had to identify why or what was the fraud that was committed or what was the perjury.
You do.
So I had to. I was just quick, it was a quick one. Most of it was like a one sentence summary of what happened and why I, feel like it was, fraud, perjury, whatnot. But now that you mentioned that, let me try to see if I can. Because what I don't want it to be is that, 4:30 on a Friday, last complaint that they read and they start to get, yawny with it, and dismissal with options to the man,
Yeah, no, I get it. I get it, and that's the assumption that you always have to make, is that, you know, your paper is the last pile on the stack at the end of the week, at the end of at the end of a really long, difficult Friday, and you know the judge just got a call from his buddy who's waiting for him at the bar.
You know, from college that he hasn't seen in 10 years.
Yeah,
you know, like,
and he says to his friend, "Hey, look, man, I'll be there as quick as I can, but I got this one last thing to look at." So you know, keep that in mind and make it easy on him.
That's what I've been trying to do. I've been trying to draw him in and hold on to him, you know, throughout the entire complaint.
Yeah. But as
my last question, real quick, is if I get lucky enough to get dismissed without opportunity to amend, does that mean it's over?
Yeah, if they dismiss it with prejudice, it's over, but it's not totally over, because then you have to decide whether or not you're going to appeal.
Okay.
So that after an appeal, you know, it's officially over. You have no further right to go up to another court. You can file a writ. We're just talking about the writ process with questioner. You know, the first appellate level, it's always an appeal as a matter of right. You have a right to be heard, a right to review. But when you get to the Supreme Court, whether it's state Supreme Court or federal Supreme Court, you have no right to review there. It's totally discretionary with the court. They can say, "Oh yeah, okay, we'll take a look at that," or they just send you a postcard that says "denied, fuck off." It doesn't actually say "fuck off," but you know, you get the idea.
Definitely.
So you only get really one level of appellate review that you get as a matter of right. One thing I wanted to tell you, though, before you moved off your first question, was that for the elements now, at least in the Ninth Circuit, for judicial deception, they've sort of clarified that you'll have to meet the pleading requirements for a fraud claim, and I think that's under FRCP Rule 9. So you want to take a look at that.
Okay.
And the case that sort of lays it out for you is Benavides versus County of San Diego. And that was a Ninth Circuit case. It came out, I want to say, in 2022. Might have been 2021. I don't remember the dates on these things. It's yeah, it's taxing enough on my poor brain to remember the case names, let alone the dates that they came out. But I'd take a look at Benavides as I was going through the complaint.
Okay.
Make sure that you plead your judicial deception claim so that it meets the requirements set out under Benavides.
Yeah, I when I was going through the Scholar and they were, I was reading some of the, at first I searched, just what, cases were against CPS, and then what, then I kind of fine-tuned it down to my, local area, but, they were discussing, the requirements or something with judicial. This one wasn't in regards to fraud, but it was judicial, and I was like, ooh, let me go ahead and kind of see how they got tossed out to make sure that I can try to meet that expectation, because I mean, as much as this been taxing on me just as an individual, I mean, the effort that I'm putting in, I'm not that poster if they throw my shit out with no opportunity to me on a picket line or something.
Right.
I don't know, man, something, but it's a little reassuring to know I got at least a Hail Mary in the appeal should it be unfortunately not picked up,
Right.
I'll try to walk on draft and
I don't think they do walk-ons on in the appellate court, but
I'll be the what was his name, Warner. I mean, I'm buying them groceries right now, but next year we'll be in the Super Bowl.
Oh, gotcha, yeah. So you think about, you're learning a lot about the law and about all this stuff, and I know this is kind of a song I've sung before, but you should consider looking at, maybe going to law school and taking it a little step further.
Man, I can't lie. I mean, every time I learn one of these new hanging points like the proof of service and what option you took, I mean, it's, and I'm one of those people like I'll never forget these self-taught hard lessons. Like that could have been ugly. It just would have been very delightful, in getting things done. And I would have tried to move to the next step. They go, oh, I got you. You didn't, acknowledge it in time. But technically, I did the certified mail, with the 2 copies of the proof of, receiving it. And I'm like, she must not give, 2 shits because, she responded, but then I'm thinking to myself, let me go double check it and make sure. And I pulled up the form. I think it's like POS 50 or something, and that's the one where you can serve them to the matter. It can be anything else as long as it's not the summons and not the complaint. And you can go by mail first to 10, no problem. Boom, I hope you got it. But the first 2, which I understand are the most important, you gotta try to shake hands and make contact. But
but you can't. You can't be the one, since you're a party to the action. You can't also be the one to serve it, right?
That I knew from small claims court, but I figured this is the whole nother league. I mean, a lot of this stuff is the same process and same requirements, just different venue. But luckily for me, I have a pretty decent network. I got a friend that stays in Vegas, and she lives in Henderson, so it's nothing but a little 10-minute drive for him to go over there for his high school buddy. So.
Oh, nice.
Because I looked up online how much is to serve these people. I'm like, man, it's kind of expensive, but I have friends there. At least, I really make sure it got done. But thank God, I have a network to tap into.
Yeah, I always used to enjoy doing service before I became a attorney. I used to do like hard service for people, and by hard service I mean the service where they're
dodging you.
Yeah, they're dodging you, and they don't want to get caught, and they're they're trying to escape. And I always enjoyed that stuff. I'd chase those people around, and sometimes they'd call the cops on me, and the cops were always really cool. They'd come out, I'd explain what I was doing, and my conduct's totally privileged, so I can do all kinds of things, and there's no problem with it. Frequently, the cops would say, "Well, let me go give it a shot." And they'd take the papers. And then they'd go knock on the door and say, "Yeah, it's police. We're here. We got your call." Whoever would come and answer, and then they'd turn to me and say, "Is that them?" I'd say, "Yeah." They'd lay the paper on them.
Is it true that they don't typically have to take it from you as long as you touch the package to them? Like, you don't want to smack them on the chest, knock the wind out of them, but as long as it hits them and falls, it's on them, right?
Yeah. I've done things before, like the person's in their car and they see me, that say they're like getting back from getting groceries or something, and they'll roll up the window, and I just walk up and slap the complaint right on the windshield, put the windshield wiper down on it.
Oh, that's good enough, huh?
Just tell them you're fucking served.
Yeah. That's what I told my friend. I said, if there's any kind of jazziness, because if they just crack the door, look, all you gotta do is toss it in there, and you're good to go, and I'll tell you what this, on the proof of service.
Well, you gotta positively identify your person if you're doing it on the first service.
I already sent pictures of what her husband looked like and what she looked like, so he knows.
But even with a summons, you can do a sub-service once you've made reasonable attempts to get them personally. Because you get somebody, over the age of 18 in the residence who can accept is old enough to accept the service for them. You can't serve it on a kid or whatever, but like a roommate, office staff.
At the office, I read that.
Yeah, so it's there's a bunch of little loopholes. But anyway, you got any other questions before I move on to Alyssa?
No, that's it. I appreciate it as always.
Yeah, no doubt, man. Thanks for your work on this thing, and thanks for sending me that complaint. I was very, very curious to see what all the technology did with it.
It turned into Harry Potter's 8th edition, right?
Right.
Let me clean it up for you, and then you can kind of get a better idea of how it tracked.
Sure.
Yeah, I appreciate it.
Absolutely. So, hey, Alyssa, haven't seen you in a while. How's it going?
Hi. Yeah, we just got moved into a new house.
Oh, nice.
Spanking new house.
How exciting.
It's been pretty exciting. I'm never moving again. I don't enjoy moving at all.
Yeah.
And so this is going to be the last time I move. But I'm still waiting on the judge to rule on my motion to dismiss.
Mm-hmm.
Is there, I know that there isn't in the Federal Rules of Civil Procedure, there's no time frame that they're supposed to have that done.
Nope.
Is there anything at all that kind of gives them like
am I just going to sit here and kind of be biting my nails until it's done? Or there's nothing that kind of gives any type of guide? There's no standard or anything?
Yeah, I don't know if you were on yet when I was talking about the, what case was that? Hipschman case.
I wasn't.
Yeah, I think it was just me and Think Missa. But let me open it here real quick. And I'll give you the... All right, I've got it on screen share so that people watching the recording later will know what we're talking about here. But the reply was filed. The county's reply in support of their motion to dismiss was filed on February 22nd, 2023. And we're sitting here right now, what is it, the 23rd of July, and we don't have anything from the court in terms of a decision, an indication there's going to be a decision, nothing. Just crickets for whatever how many months is that? 4 months, 5 months, something like that. And yeah, we've got nothing. We're just sitting here and waiting around with our thumbs up our butts. Discovery's not open. You know, nothing.
It's driving me crazy. I don't know what to think and what's going to happen, so I'm just sitting here. My anxiety is through the roof. But I guess in the meantime, I've been speaking with a couple of families here in Montana that have had their cases have closed, who have come to me and said that they've possibly had cases, and unfortunately, a majority of them are not anything that would be worth pursuing. And that's kind of been difficult having to really relay that message to them, and I think that a lot of the times people really think that they have a case and they don't, and I'm having a hard time saying that to them that they don't.
Yeah.
Because,
well, this is the thing, and I'd be very careful about it, because when you start advising people, like you have a case, you don't have a case, or you have this right, you have that right, especially given the position that you're in, where you're a pro se litigant and you've actually got some court experience. I know there's a strong temptation to go out and try to help other people or review their stuff and advise them, on their legal rights. But you really want to be careful about that, because you're walking a fine line of, right on the edge of practicing law without a license, which in most states is a crime. So
absolutely.
You want to be very, very aware and cognizant of that when you're talking to people about their situation. And
I strictly say advocacy, like it's advocating or helping. That's what it is. I'm not.
Yeah.
Even to that extent, it's.
What you might encourage them all to do is, and you've done a lot of research just in writing your stuff and opposing your motion, doing your work. You've, in fact, everybody here and everybody on the YouTube channel, for the most part, at least the people that regularly come in the chat and the live streams, they've all done a ton of their own research, a ton of their own legal work. They know where the resources are. They know what cases, at least in their particular circuit, they know what cases to look at. And what I encourage everybody to do, it's not giving legal advice or practicing law without a license if you just share your resources with them.
Absolutely.
That's it. You say, oh yeah, you know what? Your case sounds kind of like this case I read, say maybe it's Benavidez. You might go take a look at that and see what you think. See, that's not saying anything about their legal rights or whether or not they have a case or don't have a case. It's just giving them a resource or a path to a resource where they can look at it and make their own decision. And that will prevent you from, getting in any hot water about practicing law without a license. So you just share your resources. Share your resources with people, and there's nothing wrong with that. But you want to be careful about telling them, oh, I don't see a case here, or you don't have a case here, because it could turn out that they do, and they didn't take action on it because of advice that you might have given them, and then they either come back and sue you, or they file a complaint against you, or some other such thing. So you just,
That is a great thing to keep in mind. I never really thought that much into it, actually, so that, yeah, absolutely.
Yeah, you want
Glad we
to.
had this conversation, because I don't want to be in trouble for anything, absolutely not.
Yeah, no, you don't. And then, I mean, that would also impact your ability if you got busted for something like that, or any of you guys. Really, this is for everybody that's listening, and it's worth paying attention to. If, for example, you did get popped for example, practicing law without a license, and then say you do want to go to law school, do want to become an attorney, they're going to do you're going to have to do a moral character application. In that moral character application, you're going to have to lay out in excruciating detail every crime you've ever been charged with, all your infractions, any lawsuit you've ever been involved in. I mean, all kinds of deep, detailed shit. And you don't want a criminal conviction for practicing law without a license to be one of the things that you're disclosing. So
I'm so glad we had this conversation, because I think we should have discussed this earlier on. Because I think that with everybody that can't find attorneys, and then us being, having the research, doing the research and knowing what we do, we want to help, and we just get kind of, I know now that we've had this conversation, I realize that I've kind of just went in and did it and helped, and I didn't even have that that thought.
Yeah, well, I'm actually really glad you brought it up, because I agree with you. I think that people who get into this, just by the circumstances, they want to help. I mean, you've been drowning, all of you. With the kids taken and all the crap that goes on in the juvie court, you're drowning, and you made it through to this point, at least in some regard. And the natural inclination is to want to help other people who are in the same situation. They don't know what to do. They're drowning. It's a morass of shit that you would never expect to experience. And so you want to help them. And you just don't think about the consequences of maybe helping them, too zealously. So this is good that we've had this conversation, because like I said, we screen record, and this will be up Tuesday or Wednesday, and I think it's important for everybody that's on the YouTube channel to take heed, and maybe to rethink the way they're trying to help people. It's better to guide people to the resources they need that you discovered along your path, and let them make their own decisions, as opposed to telling them, this is what you've got or don't have, or this is what you need to do or not do. It's better to just give them the resources and maybe help them figure it out, but not necessarily tell them the answer.
Agreed. I'm going to be moving forward a little bit differently, for sure. It kind of freaks me out a little bit.
Yeah.
But we're good. Yep, my approach is going to change a little bit. I'm not an attorney. I may have learned a lot, and I feel kind of good about it, and I'm confident about the knowledge that I have obtained, but I guess, like you said, I get kind of big-headed about it. Now I'm like trying to act like an attorney, and I'm not, and that's...
Yeah, be
I get
careful.
in trouble if I'm not careful.
Yeah, be careful. You should do the law school thing too. All of you guys should do it. I think it's a good idea. You've all learned a lot. You're coming a long way through this, just this trial by fire. And there's no better way to learn, at least the specialized material that you're focusing on. There's no better way to learn it than to do it, get beat up a little bit, go back and fix it, get beat up a little bit, learn from your mistakes, do it again. You learn a lot through, and it's a painful process, no doubt, but you learn a lot that way. So did you have any other questions or anything before
I think that's all I had. Essentially, I'm just waiting for him to decide, and I don't know if it's a good thing that he's taking so long, or if it's a bad thing. Is it easy taking so long because he's really looking into things, or is it just because he's busy?
It's because he's busy.
Yeah.
Yeah.
And in the meantime, I'm sitting here going crazy, stir crazy.
Yeah, I don't read too much into it, but what I try to do, because it gets kind of irritating to me too, we have to plan our entire work year around our caseload, and if we've got this one that's just sitting here, kind of jamming up the pipes, it makes it difficult to forecast, 6 months, 8 months, a year out, which I have to do to decide what my case, to decide whether or not I'm going to accept any more cases, for example. And so, yeah, it does get frustrating, but what I do is I just kind of assume it's gone, assume I'm going to lose, I'm going to have to appeal or do some other such thing, and schedule time in my life for that.
That's what I've been doing. I've been fine with the lose.
Yeah.
And kind of finding my approach after that, but
Yeah, and then you just don't worry about it. Once you've made that, you've pigeonholed it into that box, you put it up on a shelf, and don't worry about it again. When it comes, it comes.
yep.
And that's,
Good deal.
yeah, that's generally a good way to do it. So I got about 7 minutes left. Did anybody else have any questions or comments or anything?
I do.
I have another question.
Okay, let's do think Missa first. What you got?
So I have a question on, this is Morris's, so he has, 3 social workers that he served that were no longer with the county, they were served at the county. So they appeared on the case as a special appearance. Is there anything while they're specially appearing that can result in them being served in that process, or provide details about their address or contact number or any information that would lead to service on them?
I'm assuming that they're specially appearing to challenge service, right?
Yes,
Okay, and how did he serve them?
through the county. And the county accepted it.
And it turns out the workers no longer worked for the county at that time.
Correct.
Is this LA County, Riverside, San Bernardino? Who is this?
San Bernardino.
Who's the attorney again?
This is Leah, it's county council.
Oh.
Leah something or another.
Well, and is this in federal district court?
Federal. Mhm.
Okay, what he might do is file an ex parte application for leave to serve one interrogatory as to each of the unserved defendants, requesting their last known, address.
Okay.
And or actually might not even necessarily do an ex parte app to do that. Might just do an ex parte application requesting that the court order the defendants to provide last known address, or alternatively grant them leave to serve early discovery.
Okay. That's a good one.
Another thing you might do is, get on People Finder, Lexis, or whatever resources are out there, do a search on these people, and then have a process server just go nail them on a Sunday at church or at their favorite bar or wherever it is you can get them. That's super inconvenient. Whenever I have a hard service or the county council being a dick about service, that's what I try to do. I try to find the target somewhere that's super embarrassing and inconvenient and start serving there. And generally
Right.
what'll happen if you have more than one person that county council's being a dick about, after you hit the first one, you'll get a phone call saying, hey, whoa, let's just, work this out.
Right. So I guess my follow-up question, and you might not know either. So because Morris proceeded on the IFP review, it's supposed to be served through U.S. Marshals. He does have a last note. Well, he did like a paper search kind of thing.
Yeah.
So he went to U.S. Marshals and they said no, they're not going to reserve the social workers because they already served them at the county. Will there be some kind of motion that needs to be filed with the court to reorder the U.S. Marshals to do it, or just generically go straight to process servicer?
I don't know if on my end of things, I would just go straight to a process server or to a friend or something. But I don't know what the rules are for a pro se, whether you can go back and make an ex parte app to get the marshals to do it again or what. I just don't know.
That's what I was thinking too. Again, it's just like one of those really weird topics that doesn't happen very frequently. So I was just trying to see what your thoughts were.
I would probably just go right to a process server. In San Bernardino, I don't remember who we use. Have Morris shoot me an email and I'll figure out who we use up there. If it's like southern Riverside County, and it's a super hard service. There's a guy down in San Diego named Tim Wing, and he always gets his guy. In fact, he's the guy that I've used to track somebody down, follow him into church, sit down next to him in the sermon, and when the little donation tray comes around, drop the papers in the tray and say, "You're served, motherfucker."
Dang, that's fun. Now it's Victorville. We're talking Victorville.
Oh yeah, that's way too far out. But yeah, you can do that sort of thing.
Right.
And the guy that I use for that kind of service down in San Diego, his name is Tim Wing, and he's good. He gets his man. So with that, before we cut it out here, let me get to a question. I believe she had another question. If I'm correct, I thought I heard you chime in there. You want to go ahead and let us know what it is? Well, I don't know that she's still here. Still muted. There you go.
You can't hear me?
I
Can you hear
can
me?
now. I can now. You were muted.
Oh, sorry.
Yeah, that's okay. You there? I can't hear you. You there? Hello?
Yeah, I am. I'm going closer to the modem because it seems like you were losing me.
Yeah.
Can you hear me now?
Yeah, I can hear you now. We couldn't hear you. We couldn't
Okay.
hear you at all prior.
Sorry. I had a trial in state court,
Uh-huh.
and I requested a court reporter under the indigent law, the Jameson versus Desta. They didn't give me one. And the judge wrote a memorandum order,
Uh-huh.
a big long memorandum order, and there are a number of things that are just patently false, and the court, the clerk, the minutes, like for example, the dates, saying that something was outside the relevant period of time when it wasn't. I mean, and there's no evidence of that. Am I totally stuck? Or, I mean, if the clerk's minutes show the correct dates and the judge got them wrong, and so I'm not ruling on this because it's outside the relevant period of time.
Oh, you just do a motion for reconsideration and attach to it the minutes and say, hey, look, you got the dates wrong.
Well, I filed a motion for a new trial, and he just blew it off.
Yeah, a motion for new trial is not going to do it. If he made an error, okay, it wasn't on a dispositive motion, right? It wasn't like a summary judgment motion or something, was it?
It was the trial.
It was the trial itself, and you filed a motion for new trial, and he said, no, you're untimely?
Untimely, or just wasn't going to do it, but I raised all the issues about, like, hey...
Well, no, it makes a difference, because if he says you're untimely because these are the dates, and the minutes reflect different dates, then it's a motion for reconsideration that needs to be filed. If, on the other hand, he said, you're untimely, but I'm going to deny it anyway for all these other reasons, then your recourse is an appeal.
Right, and the appeal got messed up for technical reasons.
Yeah, so they're unrelated. Those are completely unrelated issues. Your first question was, he got the dates wrong and denied my relief because he said I'm untimely, and I'm not. The answer to that question is file a motion for reconsideration, give him the correct dates and proof of the correct dates, and ask him to reassess. On the other hand, if he ruled on your motion for new trial on the merits, you're asked out.
Mm-hmm.
Yeah, you can't mix the two. If he either he ruled on it on the merits, or he refused to rule on it at all because it was untimely. If he did both, then it's as if he ignored the untimeliness and went ahead and ruled on the motion on the merits.
I'm going to have to read what he wrote in the motion for new trial. Thank you.
Yeah, it makes a difference. The technicalities make a difference. EM, you just showed up late. Guys, getting ready to get off, but since you did pop in, if you have a question, I'll give you an opportunity to go ahead and ask it. We'll answer it, and then that'll be the end of the day.
I just popped in there. I listened to everybody else's.
Oh, nice.
For a minute.
Yeah, it's all good. So you don't have anything?
Nope.
All right, cool. Well, with that, you guys, I'm going to shut it down because it's 6:02 and James needs to team the UN so that he can set this thing up for the, what do you call it? The live stream with the remainder of Susan Pender. It's going to be a long one tonight because we're trying to finish that thing. I was talking to him about it last night. It's like, dude, we gotta finish that up, man. We can't be there forever. So we're gonna have a long live tonight with Susan Pender. We're gonna get that thing done. I don't know who he has slated up for Tuesday, but thankfully we're done with the Pender Bender. Samuel Robertson, sorry man, you're late. We're shutting it down right now, but I did screen record. And we did cover some interesting stuff tonight. James will be posting it, I'm not sure, I think Tuesday or Wednesday on the YouTube channel on Caps and Stems. Thank you for joining us, but I apologize that I gotta shut it down.
I do have a video clip to send you of my common counsel making a comment about my complaint and that I obviously have an attorney behind me somewhere. Because it was better than we could have done in the federal circuit.
Oh, nice.
And I based it off of your template. So I'll cut that for you. Where should I send it to?
Send it to capsandstemslaw@gmail.com. I'll put it here in the chat. It's CAPSANDSTMS law@gmail.com. I think that's right. Yeah, caps and stems law@gmail.com. Yeah, send it there. So what venue are you? Where are you?
I'm in federal appellate court right now.
Yeah, but where?
Seventh Circuit.
Oh, 7th Circuit. 7th
Yeah.
Circuit
Yeah.
is okay on these parental rights cases. 9th, 10th, 11th, and 7th are generally, more or less, not on every issue, but they're more or less aligned. So, as long as you've done it right and you've got a righteous claim, you should be okay there.
Yeah, I hope so. They're trying to get me on Rooker-Feldman right now, which doesn't apply at all because I have my daughter. I'm not trying to overturn the judgment that takes my custody. So
Yeah, you want to make sure that's stated in your complaint that you're not challenging the custody order. Not only are you not challenging it, but you've got your child.
yeah.
Yeah. With that, I'm going to have to cut out, guys. James has got to get on my machine to get this thing set up for the live. So I'd love to sit and chat longer, but I really can't do it. Good night. We'll see you guys. Thanks for joining in.
Yeah, on YouTube.
Thank you.
All right. Bye.